Hello, everyone, and welcome to another edition of our Knowledge for Life alumni webinar series. My name is Charlotte Wara. I work with the registry team here at WMU as the alumni assistant, and I am excited to be hosting today's session. Today, we will have a presentation from our colleagues, Dr. George Theocharidis, who is a professor of maritime law and policy, together with Dr. Henning Jensen, professor of maritime law and policy. They will be presenting on the topic, the Ever Given a Legal Status Update. We are going to have about 45 minutes for the presentation and about 10 to 15 minutes for the Q&A session. So please feel free to submit your question using the Q&A section. The recordings of the webinar will be uploaded on our YouTube channels in the days ahead, and the presentation of this webinar will be sent to all our participants, including questions that were not answered during the session. So without any further ado, I would like to kick things off by welcoming Dr. Henning. Over to you.
Thank you very much. And let us not lose further time. I will just go right into the discussion of the Ever Given and the legal status update. I would like to share with you here the outline of today's webinar, where we actually have to cover quite a number of aspects. And it is also important to note that these aspects are often very much interlinked. So for example, my colleague, Professor Theocharidis, will address the matter of arrest claims and limitation of liability. However, that is deeply interlinked with salvage-related questions, general average, and other claims-related aspects that I will address. So you see what we would like to do. It is quite a challenge for us to master such complexity in a short time frame, but we will do our best. I will start with our webinar by reminding us a little bit of what happened and to add some information, some of the important aspects of the Ever Given incident. And then we'll end up after about 45 minutes, maybe 50 minutes, with hopefully enough time left for a Q&A session where my colleague and I will be happy to answer any questions or hear your comments. So the introduction, that is what we will try to address first. And that is basically the background of the case. By the way, I just checked before we went live where the ship is actually now. And it has not arrived at its destination, at its discharge port in Rotterdam yet. Actually, she is just about to cross the Strait of Gibraltar. So it will still take a couple of days for her to reach the discharge port in Rotterdam. And then, if you look at, for example, the agenda item G, some cargo interests, some cargo owners will, for the first time after more than 3 months, be able to see how the cargo, actually the status of the cargo, how it looks like. But we'll get to that in a moment. So let us remind ourselves what happened, and that will be very, very quick. On the 23rd of March, we had the situation of the Ever Given. This is a tweet from the day when the news broke. We had the Ever Given stuck in a very, very awkward position, and the Suez Canal Authority had to dispatch tugs trying to pull it free. And we all know that the situation emerged to be a little bit more difficult. I wanted to add one aspect here. The fact that a vessel blocks a waterway is not something that is completely new and that we witness for the first time. For example, Europe's most important inland waterway was blocked 10 years ago for 32 days by this inland waterway vessel. However, I'm fully aware of the fact that here we are talking about a 400-meter long vessel and not a smaller inland waterway barge or ship. But the situation in itself, that a ship is the result of a a blockage of a waterway is not completely uncommon. And actually it happened also in the Suez Canal, but these incidents were minor and not as spectacular as the picture that we all know, where this massive ultra large container vessel, 400 meters long, blocks the waterway, and basically these news, you all know this, these pictures with a little excavator machine went viral, and for 6 days the ship and everything related to the ship was really global news. And unfortunately, I would like to add also a number of people making fun of the situation and basically not seeing the complexities and the difficulties caused by this event. But we all know this, and I would like to keep it very short in terms of the summary. So it is also important for our further discussion to just have a quick wrap up of who the involved parties are, not complete, but the most important ones. The ship flagged by Panama, owned by a Japanese owner. By the way, one of the very few owners who is a subsidiary of a shipbuilding group. As I learned, Japan's biggest shipbuilding group, and so the Shoei Kisen Kaisha, I don't know if I pronounced that correct, is a subsidiary of Imabari Shipbuilding Group. We all know that it was time chartered on a long time charter by Evergreen and managed by a German ship management company. The insurers are important. The P&I Club is the UK club, which also led the negotiations later, but of course joined by all other parties. And the hull and machinery insurance of the ship is a conglomerate of several hull and machinery insurers from the Japanese market. And then the cargo interests that will also be relevant as we move on. Some big names represented there, you see them. Reportedly, the ship had 17,600 containers on board. And it is not, it's not even the case that just one party would represent one container. There could be actually quite a group of different cargo interests represented just by one container. So that adds up to potentially thousands and thousands of cargo interests, which are eagerly waiting until today to get the cargo and to see the status of the cargo in a few days in Rotterdam. So these are the involved parties, and my colleague will also make reference to them. It is also important when we just wrap up the facts that the Suez Canal is an artificial waterway with a special status. When the news broke, for example, I personally had some questions whether this is an UNCLOS case, whether there's any relevance to the law of the sea, and my answer was generally no, only if the flag state would completely escalate this to a prompt release of vessel procedure, which did not happen, which I understand was never on the table. So rather we have this very old convention, and which was confirmed by Egypt in the 1950s, that the transit is subject to international rules. But apart from that, it is completely under the sovereignty of Egypt, and managed, operated, maintained, utilized, improved by the Suez Canal Authority, where I included here the link. It is important also for the further discussion that there are specific rules for the transit of ships. The tolls, we don't need the tolls for the webinar, but the Suez Canal Authority for the rules of navigation, they will be important. At least I will make a quick reference to two provisions where, for example, we learn a little bit more about the pilotage rules. And also there is a rule in these navigation rules about which is entitled responsibilities, which is also important for the proceedings. So we have here something that is subject to a special status, and the parties actually exchange quite different legal views about these rules. By the way, both my colleague and I, we don't give any kind of legal advice here. We express our personal views as legal scholars, and we are of course dependent on the information that we can find using all sources that are available to us. So the facts move on. We know that over these 6 days of the vessel blocking the passage through the canal, there was a massive congestion building up both at the south entry and at the northern entry. The numbers reported were more than 400 ships lining up in those waiting areas in the Mediterranean Sea and southbound. And some took the decision to reroute across the Cape and basically taking into account that this would take a lot longer than to make the crossing. So these waiting ships and this big number of ships also affected by the situation is something that can potentially also be relevant later. I'm just mentioning it now as the facts. We learned when the ship was stuck from the 23rd of March that, of course, there were the tugs that are operated by the Suez Canal Authority. They were quickly there, but they were obviously, in terms of their bollard power and in terms of what they can do, they were not enough. So the Suez Canal Authority usually tries to handle those situations on its own, but this was a situation beyond the pulling power of the tugs available. So it was actually quite quickly reported that a Lloyd's open form had been signed by the owners with big names of the salvage industry that you can also see here, Smith and Nippon Salvage. And I included also the link for this information. So we have actually the tugs run and operated by the Canal Authority, and then the private salvors that were engaged by the most commonly used salvage contract in addition to that. But of course, it took some time for them to get to the site. I try to highlight here the tugs that were there from the beginning. It was reported that over the course of these 6 days, there were 11 tugs and 2 dredgers involved to get the ship free finally, so quite a big number, and a mix of the Suez Canal Authority tugs and private tugs involved. Now, we have to wrap this up quickly. We all know that after 6 days, the ship was successfully refloated. It was possible to bring her to the Great Bitter Lake. This is a satellite picture here. Of course, then inspections had to be undertaken and the negotiations started. It was reported that it took some time to exchange the views between owners, in particular charterers, and the Suez Canal Authority. And on the 7th of April, the ship was arrested officially. And as we understand it, also the cargo was arrested. At least it was not possible to undertake any kind of transshipment. So a period started where the ship was officially arrested under the law of Egypt. And the negotiations actually took quite some time. Several meetings at the competent court. And I have to wrap this up. After more than 100 days, difficult negotiations between the Canal Authority and the involved parties that you saw earlier, we all know that the ship was finally, based on a deal which is subject to confidentiality, released. And then it could, of course, after further inspections, start moving on and encountering further trouble than in the Mediterranean Sea. So quite a long period of negotiations that are relevant for what we would like to discuss with you and as we move on here today. Because during those proceedings, during the negotiation phase of more than 100 days, a lot happened. The owners, as you can see from this headline, declared so-called general average. I will address that in a moment. I have very limited time to address that as a principle. But here we note that this was done. And that had an effect, because after that declaration, cargo interests all over the world, I would say, but mostly in Europe, they received the letters to sign the security, the general average bonds, for sharing the costs later, in accordance with the relevant average adjustment rules. And some of the cargo interests were completely taken by surprise because they had never experienced such a situation before. Some of them probably did not even know that they had signed this, that the fact that this mechanism could be potentially triggered. We get to that in a moment as well. But this happened starting from mid-April. Thousands and thousands of general average bonds or other forms of written security to be signed for the cargo interest to assure themselves of getting the cargo later. Then I'm almost done with the facts. I would like to highlight one aspect here. Over these more than 100 days of negotiations, different views emerged between the owners and the other represented parties in terms of the ship and the Suez Canal Authority. And we, as the ones observing the situation, we have to follow the news, and we cannot be exactly sure until today, because we don't have an official casualty investigation report for now, for example, what exactly happened. But the chairman of the Suez Canal Authority, for example, reported for the first time at the end of May that a marine unit of the Canal Authority, one tug, had sunk. You see the quote here that I took from this information item, and it was also reported that one worker had died, loss of life. And basically, the quote that you can see here is a summary of the chairman arguing that the owners had not completely honored the huge losses incurred by the authority due to the incident. Now, there's other reports about this particular event. For example, a huge story by Bloomberg, where it was stated that a few days after the Ever Given was freed, that tug sank and the employee died. So we cannot be exactly sure of, maybe the understanding of both parties is correct, but this is an example of how the news broke here, and maybe a different understanding of what exactly happened, which is subject to further investigations. And I can give you an explanation why maybe these statements are made. Again, you can see here that the statement from the chairman of the Suez Canal Authority was that during the salvage operations, the unit sank and the death occurred, whereas the other statement is a little bit afterwards. Now, let us have a quick look, before I hand over to my colleague soon, about what the rules of navigation say about responsibilities of the owner. And these rules are very extensive, and I can only highlight a little bit here one aspect. So these rules state that the owner is responsible for any damage and consequential loss caused either directly or indirectly by a vessel. So if you have a very broad understanding of consequential losses as a result of an accident, that could also involve the tug sinking a little bit later, and as a result of, for example, heavy overtime shifts and maybe fatigue arising after the immediate refloating. This is an explanation why there are different views or different statements about what actually happened. And as you can see, it is a very broad, the rules of navigation are very broad when it comes to owner responsibility, because it addresses also consequential losses, either directly or indirectly caused by the vessel. So a very broad understanding of responsibility. Another aspect relevant for the facts is the pilotage aspects and the different views about who actually controlled the ship when the accident occurred, when it was stuck in that awkward position. And the rules of navigation of the Suez Canal state clearly that the master is held solely responsible for all damages, accidents, and so on, and that the master is to be held, accountable. And turning it around, that the pilot is not to be held responsible for any damages and so on. We learned from the proceedings that obviously, when this happened, when the incident occurred, two pilots on board were not exactly in agreement about how the ship should proceed. They had different views whether to speed up or not to speed. But the rules of navigation of the Suez Canal, and this is actually in line with SOLAS, ultimately they clarify that a pilot is giving guidance, recommendations, and it's not in ultimate control of the ship, and that the master is at all times still in control. That is actually compliant with the understanding of Chapter 5 of SOLAS. So we need to await further official reports about the casualty investigations, but this was discussed at the court while the ship was detained. And there are until today different views, different legal views of who was in control. How far do losses extend, also consequentially and directly, indirectly? So the rules of navigation of the Suez Canal play quite a big role if you would like to know more and if you would like to go deeper in terms of the legal consequences. Now, let me conclude before I hand over to my colleague. A few words on salvage and a few words on general average. So the facts are done now and we move on. Salvage is subject to an international convention and it is defined in that international convention, which is also ratified by Egypt. I've included the definition here. Any act or activity undertaken to assist a vessel or any other property in danger in navigable waters or in any other waters whatsoever. The reason why I include the definition is that it was reported that some people would question, doubt, whether this was salvage at all. But I don't think that is very viable because we have a judgment, the Cape Bonny judgment, which basically confirms, if you need salvage to attend the ship before it can continue its journey, that's already salvage. So that I don't think that the discussions will center on that. Rather, a bigger question will be the reward for the salvage, because it is the common approach is that a salvor is entitled to a reward, and then the criteria for fixing a reward later are in Article 13 of the convention. But obviously, Egyptian law states that a fair bonus is due after a successful salvage, and that the payment of the fair bonus was demanded immediately, at least by means of a security, and there was dispute on how this should be paid and so on. So one of the reasons why the ship was held, arrested, detained, and why more than 100 days passed was the amount to be paid fairly as a fair bonus for the involvement of the tax or the Suez Canal Authority. So probably, that's my understanding at the moment, there is a deviation of the payment to be paid to the publicly operated tax by the Suez Canal Authority and the involved private salvors, Smith and Nippon Salvage, which will receive a reward later under the rules of the Salvage Convention. So I will get to that back to that also in a moment. Then my last remarks before I hand over: general average. Now, lots of people have heard of that. It is not possible for me to explain all details of general average here as part of the seminar, but it is relevant for the procedures as we move on now. And some people even argue, if you look here at the highlighted part, that this could potentially be the most spectacular general average case the world has yet seen. I'm not sure whether this will be the case, because I think there will be lots of settlements, but the mechanism is triggered. Why? How? Lots of people were surprised. It is contractually agreed in bills of lading and charter parties. It is in there as a standardized formulation, and it does not come as a surprise at all. It is possible to include so-called absorption clauses for smaller amounts, not relevant here. It must be declared. That has been done by the ship owner, and it is subject to specific rules that are applied in the same way all over the world. These rules are York-Antwerp rules, and then they are applied by the average adjusters, the professionals that can do this all over the world. And usually, the applied versions of the York-Antwerp rules include the salvage costs. So I wondered here whether, if we apply the common approach on general average, the four major steps that have to be tested for a general average case, there could be potentially questions of whether the costs incurred have been reasonably made. And I included here this arrow here. So technically, yes, all four requirements of general average are met, but it is possible. I'm only saying there is a potential there that some cargo insurers or cargo interests might challenge the reasonableness or this fair bonus paid to the Suez Canal Authority, which is subject to confidentiality rules, and whether these are basically, whether those can be integrated in the calculation for allocating what each and every interest represented on the ship has to pay. Lots of open questions there at the moment, but this procedure now will move on far after the ship has called in Rotterdam, far after then the goods, the containers have been discharged. And this will keep us busy, as the previous headline here had indicated. Again, I'm not sure whether it will be the biggest general average case ever, but this will stick with us. Okay, I hand over to my colleague, Professor Theocharidis now, to discuss further aspects of the case, and I will later conclude what we would like to deliver as part of the webinar.
Thank you, Henning. A very warm welcome from my side. I'm not going to say good morning or good afternoon or whatever, because you might be in different zones. We've already received a message there. There are attendants from Canada, so I will abstain from making this type of statement. Now, a couple of procedural remarks. As my colleague also indicated, this is a webinar, an academic webinar. And if anyone has specific interest in relation to the Ever Given, we are urging the participants to seek special advice on those matters, because we're not going to give any legal advice. This is just, as we stated, a presentation of course, the legal issues, the ramifications after the Ever Given incident, but in no way do amount to legal advice. Now, you've heard earlier the factual background, what happened with the vessel. And then at some point, because of probably the size of the vessel and the fact that the canal was blocked for 6 days, and you had 400 vessels waiting in line in the queue to pass, it made headlines all over the world. So many people showed interest, and many people started asking questions about the arrest of the vessel, because if you saw earlier in the slide, 6th of April, the vessel was arrested. So people were asking, why is it the case that the vessel was arrested? What did it do? So for those of you that may not be aware, if one has a claim, in other words, whether that is a claim for contractual based on contract or for any other reason, they have a right, according to this convention, which is stated here, to go before the court, the local court where the vessel is currently, and ask for security for their claim. And this is the international convention, which is depicted here, relating to the arrest of seagoing vessels in 1952. There is a 1999 version, but the 1952 is the one which is ratified by most states. It distinguishes between the provisional arrest, what I mentioned earlier about securing a maritime claim, and the judicial arrest. In other words, an arrest when you have a judgment to satisfy your claim is totally different. In this case, we were talking about a provisional arrest. The arrest which secures a claim to be adjudicated maybe later at a court, arbitration, and until the time that the judgment is issued, either the vessel is detained or the owner of the vessel may place security in the form of money or a bond or a letter of undertaking, and the vessel will be released. So this is the notion. Now, on which grounds then the vessel was arrested? Well, Egypt is a member of that convention. In other words, it signed and ratified it in 1955, entered into force in 1956. Therefore, Egypt had that particular instrument to proceed, and more specifically, the Suez Canal Authority had the right to proceed against the vessel to secure the claim that they allegedly had. I'll come to that in a moment. Now, before I get to the next point, Panama, which is the state, the flag of which the vessel flew, is not a member of the arrest convention. So there is an issue there whether that convention should apply. According to the prevailing view, yes, the applicable regime, because Egypt had ratified it, is the 1952 convention. But if the local law, the Egyptian law, provides for more remedies, then this also could be invoked. And there's a good reason for that, because the ship owner that flies a flag of a vessel, which is not a member to that convention, should not be treated in a more favorable manner. Can we go to the next slide, please? So as you can see here, there's a distinct feature of this arrest convention that the vessel may be only arrested, provisionally arrested, I repeat, if there's a maritime claim. So if your claim is not maritime, then the vessel cannot be arrested at all. Now, I'm mentioning here the possible grounds on which the vessel could be arrested, namely salvage, 1C, loss of damage to goods, 1F, pilotage, 1J, 1L, dock charges and dues, and finally 1N, master's disbursements. In this case, in the case of the Ever Given, the Suez Canal Authority pursued the claim, which was, as we said, allegedly for many different expenses, so on and so forth. I'll come to that in a moment. It filed the claim for the application for the security before the competent Egyptian court, and the vessel was arrested at the Great Bitter Lake anchorage. That's where the vessel was after it was released from where it was blocking the canal. And as was mentioned earlier, the Suez Canal Authority arrested both the vessel and the cargo, apparently because, as we will see in a moment, the salvage was also offered, the services were also offered not only in respect to the vessel, but also for the goods. Of course, these are issues which may be debated, but apparently that could be the case. However, there was no cargo interest application for security. In other words, from those claims that I mentioned here, apparently the ground on which the vessel was arrested was 1C for salvage. Can we move to the next slide, please? Now, the potential claims in a case like that, where you have a lot of interests, it is expected also that you would have a lot of claims and a lot of possible litigants. So we have the owner here, which is a Japanese interest company, Shoei Kisen Kaisha, time charterer, which at the time was, because the container vessel was under a time charter, Evergreen, which was a Taiwanese interest company. And then the event, and as you can see here, I have events. Why? We will see in a moment whether that is significant, especially for the general average. There were two events. First of all, it was the grounding of the vessel. And then you had the detention. And that abstained the vessel from going forward. And therefore, those interests that might have a claim, they could rely on those events, whether, as I said, they could be considered as one or two distinct ones. And that also is important for the limitation of liability. The results: loss of damage to cargo, we'll come to that in a moment, and delay, significant delay. The claimants, the possible claimants, well, definitely the cargo interests on board the Ever Given, those that had containers. There were a lot of containers. That particular vessel could carry up to 20,000, and it was almost fully laden. So in other words, you have a lot of containers, a lot of interests with those containers, and therefore they could possibly bring a claim against the owner or the time charter. We'll see that in a moment. Owners' charters of vessels delayed during that 6-day blockage. So apart from the Ever Given, which was there were others waiting in the queue because of the blockage. It was a backlog, and therefore those could potentially be claimants. The cargo interests on board the delayed vessels, because most of them were also laden, those vessels. Also the Suez Canal Authority, and maybe other claimants which we're not aware at the moment. For example, there was a tug and a person there was a death of one of the members, so we don't know if that person will ever bring a claim maybe before the Egyptian courts. Now the defendants, it's definitely the owners of the Ever Given, the time charter of Ever Given, the owners' charterers of the delayed vessels in respect of those cargo interests who were on board those vessels, Contributors to general average claims, yes, because as my colleague alluded to earlier, there is already general average which has been claimed by the owner. Come to that in a moment. And finally, possibly, depending also on the applicable law, the insurers. Now, the insurers, in many cases, they come not in the initial proceedings, but they may intervene afterwards. Can we go to the next slide, please? So, the legal basis for those claims. You may have claims based on different legal grounds. Ex contractu, in other words, based on contracts, whether that could be the time charter or a bill of lading. Ex delicto, meaning you might have a tort. That, of course, will depend, I'll come to that in a moment, on the applicable law. And ex quasi contractu, which is bailment, because under English law, when the cargo is delivered to the owner of the vessel, to the carrier, there is a bailment, which is also regulating the relationship. Now, the types of claim is definitely salvage. We heard that about earlier. Loss or damage to cargo. Delay, which may have caused, as a result, cancellation of charters. Off-hire disputes, whether those vessels were off-hire or not. Cargo deterioration, if in some cases there were goods which were perishable. And then damages for deviation, because you probably also read in the news that there were vessels, when they saw that this long queue was forming, they decided to go the Cape of Good Hope, and therefore you could have also issues about deviation. And finally, general average contributions. Now, the applicable law, in a case like that, you may have different laws that can apply. In other words, it's not very clear that it will be English law. English law before the English courts would be the case for grounds and reasons that we cannot explain in a webinar, but it may be the case that we could have Egyptian law applicable, especially because the salvage was undertaken within the Egyptian waters. So as you may appreciate, you may have different laws applying, and therefore the outcome of the case could be different. Few comments there. You saw earlier about the salvage. The claim, to the best of our knowledge, of course, initially was for 916 million USD. A part of it, 272 was for expenses, 300 million for salvage bonus, 344 for damages. And then the claim was lowered to 600 million. Now, the claim apparently encompassed physical damage to the canal, loss of revenue due to the blockage, and loss of reputation, as well as a salvage award. Now, the authority, and this is important to keep in mind, and this is why the authority had the first saying about salvage, the authority, according to the rules, has the exclusive rights to salvage operations in the canal. In other words, it's not like the case where you have a ship owner somewhere in the middle of the ocean making decisions about salvage. The authority has the first saying, and in the case, as you heard earlier, they also engaged competent other salvors. Now, the expected, as you see here, the loss damage to cargo, expected to be filed when cargo interests will ascertain the loss of damage at the port of destination. The vessel is on the way to Rotterdam, and then will go to Felixstowe. So when the cargo interests will be able to see the cargo in what condition they are, then they will decide what measures they will take. So this is something to be expected. As regards delay, rights may have been exercised already, and if disputed, may be submitted for resolution to court or arbitration, like the off-hire, for example, which I mentioned earlier. If there's a dispute there, then the parties may very well go to arbitration. Finally, on the general average contribution, very briefly, you heard it earlier, a lot of people are saying this is maybe too anachronistic as an institution. It seems to work, but you have to have a sacrifice. You have to have, as we say, a threat, and that threat should be posed both to safety of the ship and the cargo. In this case, there is, of course, the question whether indeed there was that threat, and depending also on the charter party and whether the bills of lading could incorporate it, what was in the charter party, you have issues whether these could be recoverable under the general average. In other words, whether the owner can invoke. We already know, and I'll show that in a moment. Can we move to the next slide? That already the owners did that, but of course we need to see what will be the outcome. Now, jurisdiction, very quickly, because the time passes very, very fast. Courts of Egypt could be a possible venue. Provisional arrest, we saw that earlier on the forum arrestee. Main claims based on tort, you could have tort claims. We don't know whether these will be entertained there. Japan, it could be if one wants to file a claim against the owner. Of course, in many cases in the bills of lading, you have exclusive jurisdiction clauses, so we don't know yet. If one wants to go against the time charter of the Ever Given, could be the courts of Taiwan. Other courts, depending on the exclusive clauses, the jurisdiction clauses, on the forum prorogatio, and other jurisdictional bases, which could be possibly the place of delivery or in rem arrest jurisdiction. Now, I repeat, in many of these cases, especially for cargo interests, there are exclusive jurisdiction clauses. So for those, it may be the case that they will go either for arbitration in London or before the High Court of Justice. And already, as you're probably aware, the owner entertained liability limitation proceedings. On that matter, and I will go to that in detail a little bit later on the slide, there's an issue whether those proceedings that were entertained in the UK, which applies the 1976 Convention and the protocol, whether they could be binding on other courts where claims could be filed. Because the important feature about the limitation of liability is that you establish a fund, and ideally all claims should be submitted there. If for some reason wants to go to another venue, another forum, then the question is that court bound by the limitation proceedings? This is an open issue. And a final note, UK is not anymore a member, as you know, of the EU. The Brussels recast regulation does not apply. Therefore, we will have an issue about jurisdiction, and then those decisions that will be issued, whether they will be opposable to the in countries, EU countries. Next slide, please. The limitation of liability, very important institution. Some people also claim that it should not be there anymore. However, it's not the time to explain. Limitation of liability exists. In other words, the liability of the ship owner is not unlimited. The limitation is an institution, a very old institution. What the ship owner does is files an application where either by setting up a fund or by just declaring the limitation of liability, all the claimants have to file the claims from that fund and be satisfied from that fund. Indeed, the owner of the Ever Given did that before the English Admiralty Court on the basis that there could be possible entities that could seek damages at that forum for the blockage of the Suez Canal. Now, keep in mind that Egypt has acceded that convention, the LLMC Convention, Limitation of Liability Convention of 1976 in 1988, that was done, but has not ratified the protocol. In other words, you have different regimes that apply. According to that regime, the English regime, you have a fund which is roughly around 114 million. This is the amount that the claimants ideally should be satisfied from. A very important statement here, salvage claims are excluded. They're not falling within that limitation convention. And therefore, and this is why the authorities, the Suez Canal Authority, arrested the vessel to ensure that there's ample security before the vessel leaves, and it will not be also limited or in any way impeded in exercising the rights. By way of information, time charter issued in rem proceedings against the owner in London. And query there whether a ship owner can indeed entertain limitation proceedings according to Article 11 for the fund before any claim is being filed. Now, according to English law, the English court must have subject matter as well as personal jurisdiction. In other words, there must be grounds in order for the court to accept this application. Can we move to the next slide, please? That's yours now.
Yeah.
I went a little bit fast, but if there are any questions, we'll deal with them. We can see them. Thank you.
Let us. Thank you very much, George. Let us cross the finish line, because I hope everyone listening to us realizes that how much everything is interlinked. Yeah, salvage, general average, the limitation of the liability, the different claims that could arise. Everything is interlinked, and it is not easy to disentangle those claims. So my attempt for the last few minutes now of the presentation is I would like to take the perspective of cargo owners, and these are the ones now who will eventually receive either in Rotterdam or Felixstowe in a few days their cargo, and basically what are their rights, what can they potentially do, and I will include that. I will include my personal assessment on that. So just generally, cargo insurance that covers the maritime adventure. It's not general property insurance, but limited to the adventure. And for, in order to recover under this type of insurance, the assured must have an insurable interest in the subject matter insured at the time of the loss. It's very important to note this at the outset. Now, there are clauses that many of you know in the maritime business utilized for that. There are more specific clauses for war and strike, for example. Different kinds of commodity businesses have their specific insurance clauses, but the most commonly used clauses for cargo are the so-called institute cargo clauses, and there's a version A, B, and C for that. Now, I will give you an example how that could work out for this case. So let us assume the ship arrives in a few days in Rotterdam, and there are cargo owners who had bought cover under the Institute Cargo Clauses A, which is the widest, the most encompassing in terms of coverage. And that's why it's also called an all risks clause. So all risks, unfortunately, does not mean all risks. There are still exclusions for certain losses. And you see the first exclusion that I added here is the one relevant for this scenario, for this case. Delay is usually, if there are no further agreements, further clauses added to the Institute Cargo Clauses, excluded from the loss. And let us discuss some more details before we end the seminar. If a cargo owner had bought cover under Institute Cargo Clauses or A, that would cover the contribution to the general average costs that this cargo owner already had to, to sign the general average bond or the security for in order to receive the cargo at all. It would also generally include any kind of salvage related costs that would be covered by the cargo by the cargo insurance. But now let's have a very detailed look. Generally excluded is loss, damage, or expense proximately caused by delay, even though the delay be caused by a risk insured against. So that is the reason why I would argue personally, just my personal opinion as one of millions of lawyers, that it is very, very difficult, or it will be very, very difficult for cargo owners which did not add further specific clauses to their cargo insurance coverage to recover from the ever given case. And a typical war exclusion clause in the Institute Cargo Clause A is the one that I quoted here. In no case shall this cargo insurance cover loss, damage, or expense caused by capture, seizure, arrest, restraint, or detainment, and the consequences thereof or any attempt thereat. So we can definitely argue that this was a situation of arrest or restraint or detainment. Maybe the reason why some cargo owners were furious and argued this is kind of piracy. Piracy is accepted from this exclusion, but I think it's ridiculous to argue with piracy in this scenario. So we can, in my view, forget about that. A typical war exclusion like this, which is usually agreed, will prevent cargo owners to recover from the ever given incident. Now, this, of course, does not mean that there could be potentially other specific clauses agreed, but generally, the delay proximately caused and the reasons for the damage, if they can be linked to the delay, will prevent cargo owners to recover from cargo insurance. And that is why I liked, for example, this headline here, one gut punch after another. That applies particularly to the perspective of cargo owners. And we learned during the 100 days of negotiations that some of them were not even insured at all. I mean, then the situation of testing the requirements of the clauses of the cargo insurance will not arise at all. But even those that had cargo insurance might not be covered for the delay-related aspects of the whole incident, and that is why this article, which was included, actually quite a short article in the Marine Insurer a few weeks ago, had underlined that it is critical for cargo owners to understand their potential risks, also for any future kind of cases. And that is where I would like to conclude. This author in this article, although conceding that more than 90% of, or even 95% of all carriage of goods by sea works fine without any incident, for the rest, he turned things around and argued that 80 to 90% of containers are moved without adequate coverage. Now, it depends on a lot what you understand by the word adequate, but if things go wrong like this, or a major explosion on board, major fire on board, as we had over the course of several months last year, for example, then there might be issues in terms of the coverage. Let's leave fire aside, because I would like to stay with delay-related aspects for my concluding slide. I think this is the last one with information. Yes, so the finish line is here. Our personal conclusions are that there is definitely a case for testing, for re-evaluating the delay-related cover. There's definitely in the future a growing market for delay-related cover for cargo particularly, but also for other types of insurance. Because if you have a look at my second bullet here, P&I and hull and machinery, they generally also do not cover delay-related costs. In any case, they must be in hull and machinery related to any hull issue, for example. And they also apply minimum thresholds of, for example, 2 weeks, 14 days. And lots of people argue the first days of the delay, the first 7, 8, 9, 10 delays are the ones that hurt the most. So this might be a reason to re-evaluate this type of coverage. If delay is agreed to be covered, it must be agreed with very specific terms, as unambiguous as possible. And Professor Theocrides alluded to the other vessels involved, the ones that had to wait. They had to wait for more than 6 days because also, that the congestion had to be resolved and so on. Maybe there's a case for more specific off-hire clauses in time charter parties in the future, updated lay-can clauses in voyage charter parties in the future. Why? If we now make the big circle, the COVID-19 impact that we can see for more than 1.5 years now has also added to disruption and fragility in supply chains. So not only do we have cases like the Ever Given, but we have the pandemic effects. We have the general congestion issues in ports like Long Beach, Los Angeles, the Chinese ports. So in my view, in our view, there is a case, to have more clarity, for more legal clarity in the future on how to cover those events that cause the significant losses of time. Now, we talked now for 55 minutes. That was it from our side. We are now taking questions, but I think it is our hope that everyone who listened to us appreciates that it is, it's not easy to single out one party and just to find out what rights these party might have. It's rather that all the involved parties have to evaluate the legal situation, and there will be definitely also claims launched not only in London but also in other jurisdictions by cargo owners who would like to test whether they have a case, maybe supported by the domestic lawyers. The situation is complex, but we conclude here, and maybe we can take some questions. I'm unsharing now. We might go back to maybe a particular slide if we needed to answer a question, but I'm unsharing the presentation for now.
While you do that, Henning, I would also like to state from my side, stress the significance of the parties, the aggravated parties should definitely have, before they decide to go to courts, they should definitely try amicably to resolve those matters. Because law at the end might be harsh for one side or the other. So it's always suggested that the parties should try and work out things, especially in a situation like that, where there's a lot of uncertainty. As you probably saw, there are issues also of the applicable law. There's going to be also forum shopping. People will try to go to the forum, to the courts that they believe that they will have most benefits. So there's going to be quite a lot of things that will still emerge. Now we will try to take those questions together with Henning. Let's see who of us will be able to.
I already see one question that I can answer quickly. So for example, how much was the settlement amount? Yeah, it's subject to a non-disclosure agreement. It is strictly confidential and we can only speculate. Yeah, and actually I don't think we would speculate here in the webinar. Maybe it will trickle down later, but it's not known.
Nobody, I dare to say at this point, I venture to say that nobody will really know unless somebody deliberately gives up that information. Nobody will know because there are a lot of things. See what happened at the start, 916 went down to 600 million. There were people saying that, oh, it could be 200, 300. Nobody will ever know. So I don't think we should get into that. The consequences of overriding a pilot in an area, especially Suez Canal, you heard my colleague said earlier, a basic principle of English law. Of course, you have also local rules that may apply. The pilot is in command of the vessel, but the master is always the one that has the final responsibility. The pilot is in control of the vessel, but the master is always in command. In other words, when he or she sees something, the final decision should be taken by the master. Of course, in this case, there were issues about the two pilots. You also read in the news. There was a disagreement there on how to proceed, but that's something that we don't know yet. These are facts, selected facts that we've seen, and we don't know exactly the case.
I can also, just 1 minute, I can also confirm this. I had the feeling when I read the rules of navigation for the Suez Canal that they confirm SOLAS in that regard. And of course, it is a completely awkward and uncomfortable situation for the master if the two pilots argue what to do, but he has the ultimate final responsibility. And that is, I mean, it will argue in favor of this situation being in a traditional error navigation later on, in favor of the master that the whole situation has to be taken into account what happened here and that the pilots were actually not in agreement, obviously, as it seems. Do you see something?
The York rules, now on the basis that were effectively incorporated in the bills of lading, yes, it will depend on the version. If it's the 1994 or the 2016, yes, the owner may be able to recover. If it was the 2004, they may not be able to recover. But
2004 is extremely uncommon in practice, yeah, because salvage would be excluded. Exactly. So it will be either 74, 94, or 2016, as you have said. Yeah.
There is a, I don't know whether, this incident will cause IMO to bring some responsibility to fix the regulations for pilots. Unfortunately, as you are all aware, there's no international convention, which has been, it's always domestic law that applies. Of course, the general rules relating to good seamanship, SOLAS, they do apply, but as regards pilots, it's always domestic law. And the countries really want to reserve that to themselves, the saying on the applicable rules. A lot of it says John professional claims to be properly covered in future connections. There's a mother case to it. Delay claims is found Brussels and UN conventions. I don't know whether you can, Henning, distinguish something else, which we will look at those questions, of course, in detail. And some of these will be answered in your email. Has the ship released in legal terms and so on, under which terms? Yes, indeed.
There's one question where you can still clarify what general average means. So I see a question here, Charles Hattersley. For general average to be effective, I understand the cargo must be delivered to consignees. Is that correct? Let us clarify. The general average has been declared, and as a result of that, the average adjusters, which were appointed by the owners, started to collect, and that takes some time. That takes actually weeks, started to collect those general average bonds, which is a financial security ultimately. And without signing, this is basically a pre-formulated letter, without signing those, the cargo interests would have trouble getting the cargo in Rotterdam or Felixstowe because the mechanism has been triggered. Yeah. So that is how I would answer this question. The cargo interests will only get their containers when they have, based on their signature of the bond or security or whatever they received in their mailbox. And that is what lots of people were upset about, because as I heard, for example, from Germany, there were German cargo owners all over, spread out the country, some of them uninsured, who had booked a slot on the ship, maybe even just a tiny fraction of a container, and did not know what their freight forwarders or the logistics company that they had asked to do that for them. They did not even know what they signed, and they did not even know that they were bound by the general average rules in the bill of lading or in the freight forwarding conditions. But they were quickly informed that they have to sign it because otherwise they will not get their cargo ultimately. So that is how it works, and that is why still a lot of people might be upset later on and trying to challenge whether this whole triggering of general average was legal at all. Because if you can, it's totally speculative now, but if you can argue the general average was not, the conditions for general average were not met, then everything has to be, turned back again. And it would be for the owners to cover this, and maybe for the time charter involved as well. So that's how tricky it is.
There's a question here relating to class and insurance. Indeed, the vessel, as you're all aware, must be properly classed. They ever given ahead proper certificates, it was seaworthy, and there is a presumption that it's seaworthy when such document exists. When, of course, an accident occurs, then there's going to be an investigation. The insurers will definitely try and ascertain the causes, the root causes. This is something that we don't know yet. We've read a lot in the news, but unless you have the full picture of the evidence, nobody can really ascertain the root causes. It's too early to do that. But definitely, the insurers, before they make payments, they will have full access. And if there's going to be a dispute, because maybe for some reason it may be discovered that the vessel may have some deficiencies, which were not discovered for whatever reason, then of course the insurance might also contest the cover. So there's going to be quite a lot going ahead.
George, can I just step in? I see one question from Miso Mudric, greetings to Zagreb, highlighting there was a case in Hamburg where the pilot was held to be grossly negligent, and the responsibility and liability switched to the pilot. Yes, but it's one singular extreme case of more than gross negligence, actually recklessness of that particular pilot. Don't know the exact details, but I remember that case roughly, and it's totally exceptional. Yeah, and I don't think maybe there are internal investigations later within Egypt about what these two pilots did, but it will not relieve the master here from being, having the ultimate final control of the ship. I don't think so. And the rules that are basically agreed when entering the transit are quite clear on that. So I would probably distinguish this.
Somebody was asking about why did the owners pay 600 million if the limit is 114 million? Well, first of all, we don't know, as we said earlier, the exact amount about the salvage, the security that was placed there. But apologies if it was not very lucid. But as I mentioned earlier, the salvage claims are exempted from the LLMC. So assuming that the liability convention will apply, hence the 114 millions will be really the fund, these amounts are really exempted. They're not there. And therefore, and this is why there was a lot of pressure to the owners to settle somehow and get off the hook, as we say, in order to proceed with the voyage.
Yeah, there's one I can answer very quick. Bal Govind Singh. Vessel was undergoing some repair you know, in terms of the hull, definitely hull and machine insurance will cover diverse costs to inspect whether the hull was okay. That's not going to be too problematic. That will be covered under hull and machinery. And obviously there was nothing too big there. So that's the bigger problems will relate to, you know, the delay related aspects and the general average.
There's another question whether the cargo interest can limit their general average contribution. The answer is no. There's no right for limitation to the cargo interest. They have to contribute. It is a very, just to say it very simply, somebody put it on the news in a very efficient manner. It's like when you finish a theatrical play and then going out with a mug asking for contributions to those that saw the film or whatever. In case you have, and this is something that may be contested, as I said earlier, in case you have a threat to the expedition, cargo and vessel, and you have to do a sacrifice to spend an amount of money in order to be able, or even throw overboard the cargo, which is in many cases the typical, the academic example that we give for general average. This is quite old. The law goes back 600 years BC. Those that had an interest in salving themselves, whether that is a property, cargo, vessel, they have to contribute to those that suffered the loss. And I think it's quite logical. However, as my colleague alluded to earlier, many people who put the goods on board and they don't take out insurance, they may have to face that problem. They say, okay, what do I do? I just need to pay the freight and then my cargo will go. But it may be the case that things go wrong. And then in that case, you have to pay contributions, which under normal circumstances, you would not even contemplate that you have to pay.
Just to add one casual note on this, I heard from Germany about, you know, traders that they for their next trade, for their next transport, they use the train, which operates from China to Germany, which takes 30 days, and they don't want to put their cargo on a container vessel anymore. So that's how burnt some people feel from this incident. But obviously, I would speculate these are probably the ones that did not insure at all. There was one question on class. I think I can also answer that. I mean, ABS, the class of that vessel, was involved when the vessel was brought first to the Great Bitter Lake to wait there, was involved when it left, when it was able to leave. So they did their job. The question about learning from the accident, how not to repeat this in the future. I mean, that's also for the Suez Canal Authority to, you know, to investigate. At some point, there will be an official casualty report. It will probably be confirmed whether this was the so-called bank effect, which sucked the vessel in or whatever. So, I mean, that's what we usually do as global international community. We try to learn from those casualties in order to prevent them in the future. But that's up to FLAG and Egypt jointly to come up with a report in a couple of months, probably.
When it will come out. I think we should wrap up at this point. We already exceeded by 10 minutes our time. We would like to thank you sincerely from our side for attending this webinar. It's been a pleasure. Again, this was an academic webinar. For those that have specific interest, you should definitely, I'll repeat it again, I cannot be more adamant on that. You should seek specific advice from those that can provide that advice based on the jurisdiction that you want to safeguard your interest. So from my side, I would like to thank you, Henning, and then we'll give to Charlotte.
I join in. Thank you very much for your attention and hope to see you at some point, either in Malmö or online.
Charlotte, now your.
Thank you all so much for the presentation, Dr. Henning and Dr. George. That was a very interesting presentation. And thank you to all our participants who always find time to register and take part in our webinar. We look forward to seeing you all in another edition of our webinar. That brings us to the end of today's session. Bye-bye.